home where he was claiming residence, and he broke into or kicked down the back door. I provided information for that, but I would be requesting a contested hearing.
Enjoy the video. Hit the like button.
I'll ask both Mr. Brinkley and Ms. Brinkley to raise your right hands, please. You both solemnly swear or affirm your testimony going to give your days the truth, the whole truth, and nothing but the truth, so help you.
Yes.
Yes.
Okay, you're both officially under oath, and I'll allow the state to proceed with their questioning. Thank you.
Yes, Your Honor. I'll call Anita Brinkley. Ms. Brinkley, will you state your name?
Anita Brinkley.
Did you attend the CSRP meeting?
Yes, I did.
Is your signature on the order?
Yes, it is.
Are you in agreement with the CSRP order as is?
Yes.
What issues do you have, if any, with the CSRP order as is?
The non-disclosure of my residence being disclosed.
Why do you want your address to be concealed?
I'm asking for it to be concealed. There have been incidents of family violence in this case, and the safety of my child.
Oh my God. Ma'am, can you remind
Mr. Brinkley, you do not, Mr. Brinkley, this is the court of law. You don't get to interrupt. She's the witness now. You'll get a moment to testify, sir. So just wait your turn, sir. Thank you. All right, well, Ms. Brinkley is the current witness. You may proceed at this time, Ms. Betzler, and we'll come back to Mr. Brinkley. Thank you.
Will you please describe the instance that you're referring to?
There was an incident where in my home where he was claiming residence, and he broke into or kicked down the back door. I provided information for that, but I would be requesting a contested hearing from the judge if possible to request supervised or modified possession orders.
Here's the deal, ma'am. Those pleadings are not before the court this time. Someone will have to plead before I can have a hearing on anything. Right now, the only hearing I can have deals with the not agreed to child support review order and the non-disclosure that goes along with that. That's what I can hear for the day. If you need something else, you will need to file the necessary paperwork or follow up on the Williamson County paperwork that's been placed in the court file that technically has, it's just for the court's information, but right now it has no legal binding on the court. It's not legally binding on the court. So at this time, I'll let the state proceed with the next question. Thank you.
Is there a protective order in existence?
Not currently, no.
Have any criminal charges been filed?
There was a report filed, not criminal charges. There's a history of family violence with Mr. Brinkley.
Was there any instance of physical abuse or sexual abuse between you and Mr. Brinkley in the last 2 years?
Not between me and Mr. Brinkley, no.
Your Honor, I'll pass a witness.
All right, ma'am, I'll be back in just a moment. I'm going to let the state call the next witness, and then I got a couple of questions I need to ask. Thank you. You may proceed with your next witness, Ms. Betzler.
Yes, Your Honor. I'll call Desmond Brinkley. Mr. Brinkley, will you state your name?
Desmond Brinkley.
What issue do you have with the CSRP order as it is?
That I can't speak with my child or see my child.
Okay.
Are you in agreement with the
sorry,
non-disclosure section?
Okay, okay, go ahead. I'm sorry, I'll let you go ahead and proceed. Thank you.
Sorry, Your Honor. Mr. Brinkley, are you in agreement with the non-disclosure section?
No.
Okay, why?
One thing I will be okay with, if she wants to keep her address hidden, that's fine with me. I just want to speak with my child. If she wants to meet up with me somewhere, we could do that. I don't need to know where she stay at. I'm not trying to pop up on her. She's not that important. I just want to be able to speak to my child and see my child. That's the only thing I'm requesting.
All right, okay, I'm sorry, Mr. Brinkley, I didn't mean to interrupt you, sir. So I had to interrupt here. Right now, sir, the only thing that's before this court is dealing with the child support review order, and that's changing the child support around, updating all that. There's nothing in this order that changes or that deals with any type of visitation. Well, it doesn't deal with any type of visitation. The only thing this deals with is your child support and the non-disclosure. So those items.
Isn't that part of the non-disclosure? Me seeing or speaking with my child? I haven't spoken to see my child in over a year, sir.
No, sir, that's not part of non-disclosure. Non-disclosure is that the personal information is not in the court file.
So what are we doing here?
We're here dealing with modifying your child support, sir.
Modifying. Okay.
Yeah,
So
that's what's before the court. That's the big thing before the court is modifying your child support, your health insurance, and the health insurance and the dental, and setting up whether or not your personal information will be included in the court order. That's all I have, sir.
Okay. My issue, if my issue is I haven't spoken to my child in over a year, and I've been fighting to see my child or speak to my child in over a year, and I keep getting the runarounds. The lady, your coworker today in the last one, they set this hearing up saying I could, state my case that I haven't seen my child or spoken to my child in over a year, and I can't even enforce my rights as a child support states. You know what I'm saying? So I thought that's what we was here trying to settle.
No, sir. The paperwork you signed off on again is a motion for entry of non-agreed to child support review order, and the only thing this review order is dealing with is the updating of child support, sir. Mr. Brinker, have you spoken to an attorney?
No, I haven't.
Might be a good idea, sir. Again,
sir, I mean this with all respect. If you, like I told your coworker earlier, I drive trucks. I could go on the road and make a lot of money, or I could come home, be a father, and don't make no money. I stay in Austin. We know how expensive Austin is. My kids wanted me back home. I came home to make less money to be a father. I don't have no money for no lawyer.
Okay.
I can't afford no lawyer.
Sir, I can't take the speech. Okay, I understand you got a lot you want to say.
But y'all keep telling me what to do, and I can't afford. I can't afford no lawyer.
The only thing that's before this court at this time is dealing with the modification of your child support order, sir. The non-agreed to child support review order. And right now, I hadn't heard anything that's going to allow me to do anything differently than grant that order, sir. So if there's anything else you want to tell me about the order that's before the court at this time, sir.
Yeah, about the non-disclosure, right? That's what we're here for, right? Me not agreeing to the non-disclosure.
Yeah, okay. Can y'all hear me? Because I think I lost audio. Sorry about that. Okay.
I can hear you.
All right. Sorry. Lost audio. Okay, it's back now. Sorry. I lost my audio for a second. All right. So again, sir, the only thing I can deal with is, like I said, the order that you signed off on agreeing to be here today. That's what the four corners of that document are what I can deal with today, sir.
Right.
So is there any legal reason that you're asking why I should not be able to sign that or should not enter that as part of the court's order at this time, sir?
Yeah, I was here not agreeing with the non-disclosure. I thought that's what we were trying to settle, is the non-disclosure.
Or you could give me a reason why I should not grant the non-disclosure, sir.
Well, for one, she's lying under oath saying the family violence. Now, the case about kicking the door down, that did happen, but I was staying there, and the cops told me I could kick the door down because that was my house. She locked me out, and I needed my things. But after that, we were still together. So that's why there is no record or no trespass and none of that. We were still together afterwards. So she's lying under oath, and I want y'all to remind her that she's under oath. Other than that, I've never put my hands on her or my child. And yes, I do have family violence on my record, but that's well past over 15 years. So that's not even that's irrelevant for her to even bring up. So that everything she's stating is false. So there's no reason why she should be keeping her address disclosed or undisclosed.
All right. Anything else, sir?
That's what we're here for, right? For the address, right?
Okay, sir. You're okay. What we're here for, sir, is for the court to agree to sign off on this order and the order changing your child support. And part of that order is whether or not I'm going to grant non-disclosure of the mom keeping her personal address in there and her contact information there. Those are the items I'm looking at, sir. Not about your visitation, not seeing your kids. That's not before me at this point. Only the information about where she's living and her contact and the contact information that she can be reached at. That's what's before the court this time, sir.
And that's what I was just speaking to. You asked me why I don't agree to that, and I just stated there is no reason for her to keep that disclosed. I never put my hands on her. I haven't done anything that she just said that happened. And again, I want y'all to remind her she's under oath because she's lying under oath.
Okay, here's the deal, sir. You got to, if you want to, that's what I'm saying, sir. I know you're not a lawyer, but you're not doing this correctly. You would have to, any allegations you make, you have to be able to prove, all right? And it's up to you to do so, sir. So you have any evidence to show that proves anything you're just saying, sir?
Any evidence?
Yes, sir.
There's no restraining order, nothing on me, or anything that she just stated.
All right. Anything else, sir?
I mean, what other questions are you asking me? She got asked a whole bunch of questions. I didn't get no questions.
Okay, well, I'll let the state finish with any questions they have of you, sir, but the questions all dealt with the order that's before the court and not anything else, okay? That she got asked questions about whether or not the child support should be changed, so forth and so on, and that's what she answered, sir. You're the one that said objection to the non-disclosure information, and this is your chance to tell the court anything else in addition you think I need to know.
Everything I keep saying, you keep throwing it out the window. So no, I don't have nothing else to say.
No. All right. Anything on redirect Mr. Brinkley, Ms. Betzler?
Mr. Brinkley, are you in agreement with the change in child support specifically?
What part?
In the CSRP order, your child support obligation change. Are you in agreement with that?
What part exactly? Specifically?
The child support specifically.
Me paying the amount?
Yes, the amount. Yes.
Yes, we agreed to that the other day or a few weeks ago, whatever it was.
And the medical support. Are you in agreement with that?
Yeah, I think I signed off on it, but I just added my daughter, even though I haven't seen her. I just added her to my insurance. She has some good insurance, by the way, medical, dental, and eye vision. I just added her just in case I knew for someday if God granted me my God-given right to see my daughter, I had that coverage. That way she could be covered. So I don't know if we could change that or not.
No, sir.
Ask
Again,
the witness,
that's not before the
Okay.
court this time. Only the issues dealing with the review order, sir.
Okay, all right. Well, yes, I'm okay with it. Yes, the dental thing, yes. Or the insurance, whatever you just asked me. Yes, ma'am.
I'll pass the witness, Your Honor.
All right. Anything on redirect to Ms. Brinkley?
No, Your Honor.
All right, Ms. Brinkley, I'm gonna give you the chance to respond to anything or anything else in addition you think I need to know. Again, Ms. Brinkley, do you file this paperwork with the court file, in the court file?
I did, Your Honor.
Okay. And again, Ms. Brinkley, this is not part of my court file, so these things they appear to be legal documentation, but not a part of this court file, but another court file. So they're at this time they're not even appropriately before the court as evidence. Real quick question, ma'am: Are there any this court order has this court has previously made court orders concerning access, visitation, possession, that sort of thing. Is there other court orders out there somewhere else that have been done on some type of emergency basis that have now are in full force and effect as far as any type of access and visitation of the child with Mr. Brinkley?
It may have been Williamson or Traverse County.
When?
2022.
And ma'am, what was the circumstances that brought about the need for Travis County or Williamson County to do something?
For the police report that was filed.
Okay, here's the deal, ma'am. A police report is just a report. It's not. This man is still guilty. He's still innocent until proven guilty of crime. So a police report has very little probative value as far as telling the court what it can give information, but it can't tell the court innocent or guilt. So for right now, that is just a report, and he's not guilty of anything, unless there was a finding by a court that he was. Was there a finding by any court that changed this court's prior possession and access orders that you know of, ma'am?
No, we haven't changed the possession orders. I'm gonna have to request, you stated in the beginning that we can request a contested hearing. So I will have to request that.
No, ma'am. No, yeah, you can only okay. This is technically a contested hearing, ma'am. Both of y'all have issues at this time, but the only thing I can deal with is the child support review order. Y'all got things outside this child support review order y'all trying to deal with here today, and I just don't have the jurisdiction to do it because it's not properly before the court. If you want to change possession access, that's got a legitimate court order in here one way or the other, ma'am, you have to file that request for modification. You've got to serve the father, and then you've got to set it for a hearing. That's the way it's done. It usually requires somebody to hire a lawyer. Lawyers are expensive, but I get it. And same with him. If he wants to change anything, he has to either do it himself or have a lawyer file for it, serve you with a copy of the paperwork, and then set it for hearing. And then that way I can take that up. But for right now, the only thing I can take up is dealing with the child support review order, and the information that contained in the rest of that paperwork, ma'am, it's not appropriate. Now, if you have any information that you're alleging family violence or you're in fear of Mr. Brinkley in any manner, way, shape, or form, you can tell the court about that. And that's only dealing with the non-disclosure issue that's before the court. So, is there anything you want to add to that information, ma'am?
I've already provided that information.
Ma'am, no, you haven't. I'm talking about testimony. The paperwork is not information, ma'am. It's not evidence. You're under oath. If you want to tell the court that there's been some type of family violence or some type of incident that caused you to have to be fearful of some type of bodily harm from Mr. Brinkley, you need to tell the court at this point, and why, and what is that based on?
Based on the incident, we haven't had communications in a while, but based on our last, when he stayed with me, or he was saying he was staying with me, he did, kick in the door. When was that, ma'am?
In
2022.
All right, you may proceed, ma'am.
We haven't been together since like 2023. So this has been ongoing. There's been numerous harassing messages. And I just feel like it's for the safety.
All right, folks. All right, I'm going to go ahead and go back over the last order in here that deals with anything concerning your circumstances, and see what as far as possession and access is concerned, and whether or not there are any prior non-disclosures granted. And I'll be back on the record. I hate to make you folks hang around, but I'm in chambers, and chambers is not made for doing hearings. So I'm going to go ahead and review the file, and then I'm going to move to the courtroom. And I will, Ms. Batchelor, will probably be able to rule on this one within the next 30 to 45 minutes, okay? But I want to go ahead and see everything is. I'm disregarding, on the record, I'm disregarding the information you filed, ma'am, because, again, it's not properly before the court as evidence, and the court cannot consider it at this time. I know that's legal mumbo jumbo, but it's something I got to do because I need to have it on the record that it's not part of the court's record, and it cannot be included in any decision I make today. So anyway, let me go ahead and look at what y'all did do, and let's see what Judge Starrett did before, and let's see what I can find out, because I see y'all have had extensive litigation before this time frame, so I want to see what the district judge did and what other prior orders we may have done. Anyway, if y'all want to take a break and come back sometime after 12:30, y'all can do so. It will probably take at least that long, all right? Thank y'all both very much, and y'all are free to go. Y'all hang around it, but I'll try to take this back up approximately at 12:30 this afternoon and when I moved to chamber. When I moved from chambers to the bench. Anyway, thank y'all all very much, and we're off the record for now. Thank you.
Derek Brinkley, it's Desmond Brinkley, and the custodial party is Anita Brinkley. Anyway, this matter was originally before the court on a original petition original petition for divorce, pro se litigation filed by Ms. Brinkley several years ago. court has gone back over this file, seen what she's filed today, and the court has already noticed earlier that the matters that were filed after the state filed their motion to confirm non-agreed to child support review order. It has a bunch of different information in it. It actually has what appears to be, it looked like a court order, but is not appropriate for this file at this time, and does not have any legal effect one way or the other. In fact, some of it appears to be evidence that has not been admitted. So that information that is on file after the state's pleadings, the court is, and will note on the docket sheet, was not considered in any manner, way, shape, or form because it's not properly before the court at this time. The court has had a hearing on the issue dealing with non-disclosure, and based on the information that has been provided to the court will rule that there wasn't sufficient evidence to order non-disclosure in this matter. Nothing there appears to be in the last 2 years, and the information is sketchy at best, and the court at this time cannot agree to grant non-disclosure in this matter. The only thing before this court is the state's motion for a modification of child support, and that's all in agreement, so that is granted. I will tell both Ms. Brinkley and Mr. Brinkley that I know y'all don't want to go out and pay lawyers to do things for you because we are expensive. But the bottom line is, ma'am, the order that you did for your decree of divorce in this matter has several holes in it, as far as visitation packages, so forth and so on. So you might need to, someone who's going to need to have to go in and clean this up so make it more appropriate. Because like I said, the holes. I mean, you did the divorce decree. You may have went to the clinic to help you do it, but it appears that some of the divorce information or divorce decree information is contradicting each other. So that means it's totally that portion is unenforceable. But since that's not before the court at this point, I'm not going to go down the path. But both of y'all might really want to go take that, see if someone takes a free consult or an inexpensive consult as a lawyer. Take your decree of divorce there and everything that's attached to that decree of divorce, and have a lawyer go over it with you and tell you what's right and what's wrong with that. Because especially on the visitation portion, y'all definitely have some problems as far as that order is concerned. But this time, like I said, I'm not going to grant non-disclosure. I'm going to grant the court order as is. Put the disclosure information in there. Because the court went over the decree of divorce, and there was nothing in that decree of divorce that planned family violence. There's nothing in that decree of divorce that said that one parent should not stay in contact with the other parent concerning certain aspects of that order. So at this time, the court will find that it's inappropriate to grant non-disclosure. Is there anything else on this one, then, Ms. Belcher?
Yes, Your Honor. So am I to understand that you are finding that the proposed order should be amended, and as amended should be confirmed to edit out the non-disclosure part, and that's it?
Correct.
Thank you, Your Honor.
All right, now I'm gonna go to the Brinkley. Mr. Brinkley, question, sir.
Do I have a question?
Yes, sir.
When can I speak to my child? That's one I'm just wondering.
Mr. Brinkley, I know you don't want your sick. You need to get some legal advice, sir, and I can't give it to you. I'm good, but I'm a judge. I can't give you the legal advice, sir. If you want legal advice about your court order, sir, get a copy of the court order, take it to a lawyer. It's the best way to do it, sir, because if you violate some of that court order, you could be before the district judge in this matter, who's down Carrie Sherry Burnett, and looking at 180 days in jail if you violate the court order, some matter, way, shape, or form you weren't aware of, sir. So, sir, get some advice, and I'm telling Ms. Brinkley the same thing, okay? I cannot give you advice. You need to figure it out for yourself, or get a lawyer to do it for you. Thank you.
So at the time, so I could be clear and to know what's going on, you saying that she has to disclose her information?
I'm ordered that non-disclosure is not granted, sir. That's legal mumbo jumbo that needs to be included in the order.
Okay. Appreciate it.
All right, Ms. Brinkley.
Yes, Your Honor.
Any questions, ma'am?
I do not.
All right, Ms. Brinkley, again, you might want to have a lawyer look at that. It looks like you've got the visitation order out of order. So the second part is now the first part of your order, and you might need to get something that's fixed that and clarified, because right now it's kind of confusing. It took me a while to go over the whole thing a couple of times before I figured out what was going on. So again, ma'am, good luck to both you and Mr. Brinkley and your child. And is there anything else from the state?
No, Your Honor.
All right, I'll actually prepare that order. Get it over to me. I'll obviously review. Have the parties review it, If they neither one have to sign off on it, they want to, but get it over to me as soon as it's practical, and I'll sign off on it as soon as practical. Thank y'all all very much, and we're off the record.
Yes, Your Honor. If y'all could go to your breakout rooms so that I could prepare the order, that would be great.
How do I do that?
I think the little man in the corner,
The-
go back to breakout room or something like that.
You should get a pop-up, sir, saying you have an invitation to a breakout room.
Join breakout room, or I just seen.
There you go. All right, thank y'all, folks.
Thank you, Your Honor.